And then the bottom of it, is it on? Yeah, you're on. Okay.
All right, everyone. We're going to get started. Welcome to our educational event, the first one we've had in person for quite a long time. Thanks everyone for coming out. To start, I want to introduce Chuck Balassi and give him some time. He's from CIT Bank. He's going to let you know a little bit about what he does.
Thank you very much. I appreciate it. For those of you who don't know me or knew me when I couldn't grow any facial hair, my name is Chuck Balassi. I'm a vice president with CIT, which is a division of First Citizens Bank. We're happy to sponsor today's breakfast today and be a sponsor of CI for many, many years. CIT is a one-stop shop for community association banking. We do business with over 40,000 community associations across the country, many that are represented here in this room, so we thank you for that business. There's a little bit of information on the tables and everything ranging from setting up bank accounts for HOAs and preparing investment strategies proposals for reserve funds, setting up lockbox and online payments for helping process assessments, and including loans for HOAs that want to finance projects as well. So my information is on there. I'll stick around if you guys have any questions. We're happy to be here and hope for a great breakfast.
Our other co-sponsors, Columbia Bank, and Andrew Bear is here from Columbia.
All right, thank you all. So my name's Andrew Bear. I'm with Columbia Bank, and actually, kind of like CIT is a division of First Citizens Bank. We have merged with Umpqua Bank, so we are a division of Umpqua Bank. So a lot of this marketing material will change, and as you get to know me, then it probably won't really matter what the logos say. I'm hoping that I can be a part of your guys' community, and I've been in Utah my whole life. Just wanted to introduce myself to you. We just opened up here in Utah. In August is when Columbia Bank came to Utah. So I've been here working for Zions Bank and Wells Fargo and also Washington Federal over the last 15 years. I'm excited to be with Columbia. I'm excited to be in the HOA space. I will be straight up front with you. It's brand new to me, not brand new to the bank. We've been doing this for 50 years, but I just want you all to know that I'm grateful for any time that you have, and I would be open and available to meeting with you, taking you out to lunch. If there's any golfers in here, apparently I have a marketing budget that I can spend on golf, so hit me up. And anyway, thank you for your time, and I do have some cards. I'll pass them out, and I'll hang out a little bit afterwards just to meet as many people as I can. And anyway, thank you, Andrew.
All right, our two presenters today are Tyler Lamar of Miller Harrison and Quinn Sperry of Jenkins Bagley Sperry. Tyler's the LAC president and Quinn's the president-elect. So they've been up on the Capitol all spring lobbying for our HOA rights and laws and trying to get things right. And they're going to tell you what's happened this year.
All right. Thank you, Andrew. Appreciate that. Let's see. Let me do it. Think I'm gonna click it this way. Is this working? By the way, I did notice Chuck got a bigger applause from us, so we know who the celebrity is in the room.
Absolutely.
Yeah.
Should we get him to just stand by us?
I think we should. Yeah. Okay, well, this is awesome to be in person again. We've done so many webinars. Quinn and I were joking this morning. We were tempted to wear suit on top, shorts on bottom, just because it's the new COVID protocol, but we decided to spare you that pleasure there. So, okay, so here's what we're going to review today. This was a very productive legislative session. we finally got one of our bills through. We have a partner at the Capitol who's been very willing to work with us. He started as somebody that introduced adverse legislation, Senator Harper, but through that process, we became quite good friends and collaborators, and he was very willing to entertain many of the ideas that we had introduced. There are still other ideas that we have and things we want to get accomplished, but many of the objectives of LAC were accomplished this year in the short run. There were some others that we were contesting or trying to moderate a little bit to negotiate some exceptions, and we had some success there as well. So we'll present on both. We'll kind of switch off here as we go, but these are the topics that we're going to cover. Many of you have probably already read about some of this legislation. If you have, we hope this is an opportunity to kind of get a refined understanding, to ask questions. Feel free to interrupt throughout. It's much more effective as we go if we can answer your questions at the time we present on that topic, and hopefully it's beneficial. So we're going to start with sex offenders. So here, let's see. This is an example, and this happens quite often, where a negative event leads to sweeping legislation, right? So oftentimes an isolated event or a couple events lead to something that we deal with. For example, a few years ago, we dealt with security camera legislation. It really restricted where an HOA could regulate security cameras. That came out of a murder that happened here in Utah, a tragic murder. And that story can kind of get some energy and push new legislation. This is very much like that. Some of you here have been directly involved in this situation. We have a community here in Utah that a board president was a registered sex offender, and some quite serious offenses against kids, and was on the board, was a holdover board member as well. His term had expired, but refused to step down. Just one of those like, nope, we're not holding an annual meeting, we're just gonna keep plowing forward. So people in the community were very concerned about that holdover control, and they were concerned because this individual reportedly was hanging out in the HOA park with his dog, which was very friendly and very friendly with kids. So the dog would interact with kids, he would interact with the dog and the kids, and he had recently also had some troubles with showing up to a Halloween party at an elementary school dressed as Prince Charming. And it was just, there was a lot going on here where the community was saying, time out, we don't like the way our HOA president is interacting with the kids in the park. So, law enforcement got involved. Law enforcement came out, approached him, and they actually charged him with a crime for being in a protected area. So, there's now two pieces of legislation that impact this, and we're going to get into it fairly quickly. It's important that we understand the distinction between the two bills. One involves state action, so it involves what the state is doing to regulate this topic, and the other is corporate action. It's not automatic, but it enables a corporation, an HOA nonprofit, to take certain action related to this topic. Okay, now, if you look at the old law, so 77-27-21.7. This is not a Community Association Act or Condo Act. This is the sex offender law. It defines a protected area, and I put in red and underlined all the areas that are protected. And notice the theme here: public, 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 public. So this individual was in what it would appear to be a public park, but it was a private HOA park. He was charged with a crime for being in a protected area, but of course he hired an attorney. The attorney filed a motion to dismiss, saying, you can't charge me with this crime. I was in a private park. And hence the legislation, because he won that motion. His case got dismissed. So, the new law, this is the actual text taken right out of the statute. It adds additional language that says, or a park maintained, operated, or owned by a homeowners association. So the protected area where sex offenders are not allowed to be has been expanded to include private areas within an HOA, whether that be a pool area or a park area, okay? So that was the state action. Now, I think this law is arguably unconstitutional, right? We don't know. We'll see if it gets tested. But we here have the state saying, you're not allowed to be on property where you have an ownership interest, a property right, okay? And typically when the state takes away your property, whether that be through eminent domain, they're bulldozing your house to create a new highway, or they're bulldozing it to make a new shopping mall, they have to pay you just compensation for what property rights they took from you, okay? Whether that applies in this context remains to be seen. Maybe this is different. Maybe the state has an overarching right to restrict where sex offenders can go, and that might include private areas where they have an ownership interest. To kind of hedge against, let me talk about one quick exception. This does not apply in a 55 and older community, okay? So it doesn't apply in a 55 and older community if the rules do not allow kids 18 or under to be around their playgrounds. I can't imagine a playground in a 55 and older community. It's possible. That's the way the statute reads. If they have a playground and no one under 18 can be there, it does not apply in that area.
Would that be like a pickleball court? Or?
It could be. It could be a tennis court or a pickleball court or a putting green or something like that. Okay. Now let's go to the corporate action component. The Community Association Act was also amended to expand the type of rules that an HOA can adopt on this topic. And the act now says that a rule can restrict a sex offender from accessing a protected area, and that loops right back to that other statute that we looked at. So the protected area will loop in the private pool and clubhouse areas, subject to certain exceptions. So there are exceptions under that protected area statute. On top of that, so that's SB 191, that was our bill. Okay. This other piece of it relates to the qualifications of board members. It is now permissible to adopt just through a board resolution. So you don't need to get a member vote, you don't need to amend your bylaws, but a board can now add additional qualifications to be eligible to serve on the board for people that have been convicted of a felony, or if they meet the definition of a sex offender under Utah law. The board or the community could make that a disqualifying factor for future service on the board. So those are both corporate action. We think those are much more likely to be permissible or constitutional under Utah law. Okay, that's our first topic.
Great. Thank you, Tyler. So that sex offender, issue, not to keep going on it, just shows how small this HOA, the group is here in Utah, is because Miller Harrison was representing the HOA, and then with some different things, they wanted another opinion, so they came to me, and I got to review a lot of that, and so it's really interesting to see, just how involved we all get in these different things and how relevant and important it is for us to get involved in legislation to help solve issues for our clients. One of these others is nonprofit corporate records. We've been talking about this for several years and trying to come through. It's also in SB 191, just like what Tyler was talking about, some of those elements. And that's the main bill that we pushed from our group was SB 191. And so for managers in the room, you don't have to raise your hand, but how many of you dealt with a records request? Okay. Those who didn't raise their hand, that's because you were saying that you said I didn't have to raise my hand, right? We all have. We all have. And it's really just the scope. And and as an attorney, I'm one of those. Hey, if I'm representing an owner on certain things and we're going to request quite an expansive scope of documents depending on what their needs are and what they're looking at. Well, this really
addresses one of those areas that has been that gray area, as I've talked to people over the years of, well, what is considered a record, right? What is it? And so there are some pending cases that are still going over that. But we think that this issue of what, this statute will limit some of the litigation that's been happening. So what it does is it defines that a corporate record. It helps give us a better idea of what that is. Aligns the language closer to the statute for the For-Profit Corporation Act. And that also opens it up for some case law that gives us some better interpretation of what that could be. And then again, it's helping remove the ambiguity of other records, which we'll look at this. So this is the statute. The part that's in the highlighted yellow, that's what was added. Okay? The other part just before that, that's in red and underlined, that was the problematic language that was leading to a lot of the litigation and the disputes. Because it's stating that, as an owner, as a director, that you can do a document request. And in the prior section, 1601, it would specifically identify some documents, which will be on the next slide. But then in this section here, 1602 and subsection 2, it includes that phrase, any of the other records. And then it didn't include so it would just be any of the other records of the nonprofit corporation. What is that? Right? I mean, you can interpret that as so expansive as it is everything. So that's been the question for years. Well, what is a record? What's a record versus maybe just a document? Right? So this legislation adds that little clarifying language of any of the other records as described in the prior section and in those subcategories. Which, if we look at that, as we look at the prior section and then the definitions as well, corporate records are going to be your meeting minutes. Okay, that's obvious. Actions taken without a meeting, waivers of notice, accounting records. I think we're still going to have some disputes over, okay, well, what's an accounting record? And we'll go through that. Membership list with the name and address of members. I know some people, they want to get phone numbers, they want to get emails. There's a case from 2015, the Walker 1 case, that addresses that. And so, if you have a member pushing back, just reach out to one of us, and we can get that case, and we can help address it. And then the governing documents of the association. So we state that in 1601, that's any nonprofit. So it's talking about your articles of incorporation, your bylaws. But then when you bring in the Condominium Ownership Act, the Community Association Act, that's where you have your declaration, CC&Rs and your rules. So we just put governing documents there. Then what we know from this statute, what is not included in the corporate record, that really helps clarify it, is the correspondence, those communications that are just, between board members, right? Or just, maybe me, I'm on the board and I'm sending it out to some of my friends in the community of, hey, this is what it is. I'm on Facebook making posts, right? Well, that's not a record of the association. That is clear now. If I'm in a board meeting and I'm making notes, or some of these similar things that we've included in some document requests in the past trying to get, it's clear those are not records that you can request anymore, right? You're looking only at the official decisions, those published documents, or the very formal records of the corporation. And so hopefully that will help a lot of you as you're dealing with these records requests. So, and that takes us to the applicability of the act.
So, quick question, Quinn. What if you have a dispute on records and you need to see the notes or you need to see the communications? Does this prohibit you from ever getting those?
Short of litigation?
That's what I'm asking.
Yeah.
That's what I'm saying.
You can litigate for some of those.
Exactly.
Yeah, you can still bring it. I thought he was posing this because
No.
we have clients where we're in a lawsuit over this.
No,
I'm like, wait. You're trying to get me to admit something?
It's on camera. It's on camera. No, that was not a trap. I just want to point out that the key balance here is if you have a legitimate concern and a dispute that justifies filing a lawsuit, you get your discovery rights. You can do that. What we're trying to head off here is someone that's just on a fishing expedition. They don't have cause to file a lawsuit, but they just want to explore all your notes and all your text. We think you should first have to have a cause of action to file in court, and then you get your discovery rights. And then, so still be careful. We've always cautioned boards, be careful about what you put in your text, in your emails, in your notes, because it may be discoverable in a later lawsuit.
Okay.
Not trying to trap you.
No, we're good. Now, we've talked about that many times over the, this lawsuit's been going on over 2 years. And he had me present on that, before the legislative session. I gave him a hard time saying, well, this kind of hurts my client's case. That's why you had me present on it, right? And he's like, I didn't even think about it. The other thing when you're dealing with those corporate records, even short of a lawsuit, and I completely agree with what Tyler said of, you still have those rights if you file a lawsuit in discovery. But when you also look at a records request, don't just look at, here's what they're asking for. The statute also requires some of those other elements of, they have to state the purpose. Why are they asking for it, right? And then, are they doing it in good faith? And for their purpose, does that tie? Is there a nexus or a connection to the documents they're asking for? And so, you can get it, and it's okay, even if you say, yeah, they want this. They want a membership list, and we're going to give it to them. They should get it. They can get it. The important thing of making sure that they have a proper purpose and it's in good faith is because then when you give it to them, they can use it for the purposes that they've addressed. And so you can limit that, right? I mean, if they're saying, I want the membership list so I can go talk to them about this issue I have with the community.
Or a new business plan or something.
Right, well, that's what I'm getting at is, I want to talk to them about this issue I have with our board or the community. Great, you can have the membership list. And then all of a sudden, if it's like, hey, come to my, I'm going to say Tupperware since they're going bankrupt, right? But it's like, come to my new Tupperware party or whatever it is these days, I don't know, Well, that's not the purpose that you could use the membership list for. And you could say, hey, that was not why we gave you that information. Now, how you enforce that afterwards, you can talk about those different options. But you want to make sure that they have those proper purposes and things to protect the HOA. Because if you're just handing out the membership list and those things, and then everybody's getting solicited for businesses, they're going to be upset at the board, right? But you can at least go back and say, hey, they asked for this other reason. They don't have they don't have permission to be using it for this other reason.
Awesome. Okay, so this next topic is actually near and dear to my heart. This exposes how big of an HOA nerd I am, okay? So the other night, I was at a jazz game. I sat next to this guy. His name was Miles Romney, okay? Well, Miles Waltman, but he's a Romney. So we make this connection, he's a Romney. And I said, hey, are you related to the Romney that created the first condo in America? And he just started busting up. He's like, that's my grandpa. He's like, but that's the first time that's the Romney that somebody asked me about. We all have our interests, okay? So Utah is actually the first state in the country, first spot, to have a condominium, okay? So our Condominium Act is very old. It goes back to the 1960s. It's actually still there, the Greystone condominiums. You can go check it out. It's like a little artifact of condo history, okay? Well, our Community Association Act is much newer. It was not adopted until 2004. Well, as many of you know, we have lots of non-condo community associations that were in place prior to 2004. The question that raises is, if I was a 1970s PUD, let's say High Country Estates or something like that, is the Condo Act applicable to my association? And we've all kind of known about this issue in the background, but we don't dare talk about it because we don't want those arguments being made. Even some of the more aggressive attorneys pursuing HOAs have not dared to bring that gun out in the fight, right? So we've kind of tabled that issue as an industry until very recently it was brought forward during a collection case by our Court of Appeals. And now we can't ignore it because it's on the books, and that's what lawyers do. They look at cases and they use cases to argue against each other. So because it was this very recent case, we had to deal with it. So this is what it looks like when a judge denies your attorney's fees, on the right here. And this is what it looks like when you don't pay your HOA dues, okay? So someone had not paid their HOA dues, and they brought a lawsuit, and they said, hey, look, we judge, please give us a judgment for the unpaid HOA dues, And by the way, give us our attorney's fees. We want you to give the attorney's fees based on the language in the CC&Rs and also based on the Community Association Act. Well, these are older documents. Oftentimes, as many of you have encountered, older documents have sloppy, ambiguous, or unhelpful language, especially on some of these enforcement topics. And the court said, we don't think your attorney fee language is good enough in the CC&Rs, so let's turn our attention to the statute to see if you get them under the statute. So they don't really take the issue fully head on, but they said, look, we're not sure the Community Association Act applies because it had a section in there that said you can amend the declaration to make applicable a provision of this chapter. And some HOAs have done that. They've said, all right, it's time to reboot, let's do an amended restated set, and we'll expressly say we are subject to the Community Association Act. If you've done that prior to this case, you were on safe ground. If you hadn't, you were in limbo. The next section, this is a direct quote, said, indeed, the CC&Rs had never been amended since their initial recordation in 1989. Well, the court goes on to decline attorney's fees, and the implication is the Community Association Act did not apply to this pre-2004 association. So here's what we did. There was a concern about just having a blanket provision that says the Community Association Act applies regardless of when you're created. Again, going back to this constitutional issue. Can the legislature step in and amend your own private contracts? Because a CC&R is considered a contract between the association and its members. Can the legislature just come in and amend those contracts and have that be enforceable? So the Office of Drafting, Legislative Counsel and Drafting, would not draft a provision that said it applies to everyone. Instead, they wanted there to be some corporate act that took place that makes it applicable to you. So what we've done is to add to 105 under the HOA registry section that if you register, renew, or update the registration with the department, then you are subject to the Community Association Act. So if an association goes to do that, so Trevor, what's your question? Okay, so he says, hey, aren't you mandated to do that? Well, if you're a pre-2004 association and it didn't apply to you, then you aren't mandated to do that, right? You see the kind of chicken and egg thing? But it also highlights, your question is important, we've all treated it as if the act applies regardless of when we're created. So the intent is if you're already complying with it, if you've already registered and you're actively updating it, then awesome. We're all just confirming and ratifying our common understanding. If for whatever reason you have a burning passion saying it never applied to me, well then you probably didn't follow the HOA registry requirement and you could continue to not follow that and stay out of it. I don't think that's going to be interesting to see if we ever encounter one of those. So, again, a problem maybe you never knew we had as an industry, kind of quietly came and went, solved through SB 191. So we're very delighted that that's no longer a question. Any questions about the applicability of the act before we move on? Okay.
Great. I have a mental image of Tyler sitting at the Jazz game, talking to this guy, and being on, not the Kiss Cam, hopefully, but like Jumbotron, and trying to figure out what's going on, because he is in this very intense conversation with the guy about condos.
That's right.
So,
That's right.
and then, the other thing you guys probably didn't even notice, but this is what I like, being good friends with Tyler, and even though we're opposite each other in these cases, he just happens to talk about the applicability of the statute, and of all the HOAs in Utah, he mentions the one that we're in the lawsuit with, and then gives me this little glance, And then he talks to Trevor about a chicken and an egg. The lawsuit involves chickens too. So, yeah, thanks, Tyler. I mean, how many more of these are we going to talk about in this one case? But okay, political signage. Oh, great, that came up in the case too. Okay, signs. So last year, if you remember, like right towards the end of the session, they threw a bill through, or it went through and addressed some of the signage, and this is also the same one about backyard issues and things, right? But the key thing was the political signage. And So what we had from that statute was talking about rules that you could not prohibit the owner from putting up a political sign, you know, or the content and the design. But what you could do is the size and then time, place, and manner of those political signs. But the question that came out of last year's legislative session is, well, what is a political sign, right? What is it? And it was like, I don't know. I mean, in today's society, you can almost have anything that's like your belief, you know, is political. So I was, you know, on there trying to find, you know, any sign that you could argue is political, right? I mean, clearly the upper left, that looks to all be political. You know, Simba, I don't know. I mean, at first when I saw it, I was like, I don't know if that's just like their cat, and then you read that, oh, because humans suck. So, okay, animals, well, that could be the political, right? Megatron, if you like Transformers, yeah, sure. And then Sasquatch, I mean, who wouldn't want to see Sasquatch? But if those are out there under the statute, I mean, if they came to us as attorneys, you could say, I mean, that could be a political view, right? That could be a political sign. How are we going to regulate that under the statute? So again, SB 191, this is where it helps us, because it then defines a political sign and really narrows the scope of it, right? And so it's talking about a sign or a document that's really specific to something you're going to be voting on, and not just in the HOA. I mean, in, you know, your elections and the votes that they're having, you know, from the government, you know, election or defeat of a candidate for public office, or you're looking at a ballot proposition. So that really does narrow the scope of what a political sign is. So that's some great language, you know. It's really just, all they did was add definition of what a political sign is for that, and it really solved a big hole that we had, a question that we've had over the last year. So hopefully none of you dealt with what was a political sign too bad.
So, honest question, not trolling you about a case we have.
Sure.
Could a flag qualify as a sign? Because last week I had multiple questions about explicative Biden or explicative Trump. You know what I'm saying? We see these flags, and the question is a flag something different than a political sign?
Well, definitely the American flag, you've got both federal law and state law, you can fly the American flag, right? But yeah, if you've got just another flag like that that's dealing with a political message, I think it falls under that. I mean, or not under this definition, right? But I think it falls under that purview because it's going to a political message, and I think you can regulate that just like you can, you know, other things. So with this, I mean, prior to this definition being enacted, I think it would be hard to regulate. With this going in, I think you can.
Yeah, I think it's still going to be tricky for a few reasons. I mean, we have sign or document here, and we have the other language saying you can't adopt any design criteria for the sign. So I would still be very cautious about a flag that's directly pointed at the defeat of a candidate. So if it's talking about a presidential candidate, I think I'd still be pretty hands off. What are your thoughts on that?
Well, you can regulate it to even the, you know, time, place, and manner.
Right.
So you could still say, we're not in the election right now, right, for a presidential candidate.
For sure.
So you can't have it up there. Now maybe if we're saying 60 days before the election,
Exactly.
then okay, they can fly that flag 60 days before November 2024.
Perfect. So I just bring that up because I think we're going to get a lot of questions about that. So any other questions about political signage for Quinn? Okay. All right. Water-wise landscaping. This was last year's big adjustment. We just have some further refinements this year. So both the Condo Act and the Community Association Act were amended. In the Condo Act, it simply requires that you adopt rules. This was last year's, okay, but I'm bringing this up to show some contrast. That you shall adopt rules supporting water-efficient landscaping, okay? This year, notice this language, and this is in the Community Association Act. You shall adopt rules required before June 30th, 2023. So we've got yet one more step towards we really mean it. you have to adopt these rules. Now, maybe next year we'll see the penalty that comes into play with it, because there is no penalty drafted into the statute. So people say, well, okay, I have a deadline, but there's no penalty in the statute. What happens if I don't? And we don't know the answer to that, but we're in kind of fiduciary duty territory, right? Like you have a duty to the association to be knowledgeable and follow the law. So arguably you would have a breach of fiduciary duty by not doing that. Mr. Miller?
I've wondered about the penalty of that. I wonder if, an argument maybe could be made, the implication is if you don't adopt it, then could you be prohibited from adopting it, beyond that deadline?
Oh, great
I don't know.
point.
I'm just-
So perhaps if you choose not to adopt rules, your association may have to just take a hands-off approach altogether, which, let me give some context to that. The HOA still has some control in this area, and I think what you're pointing out, Michael, is maybe we're gonna lose even those limited areas of control. Is that what you're saying?
Yeah, I've just been thinking about what, a good attorney on the
Yeah.
other side might argue what the penalty is.
Yeah, great question. So, again, under the Community Association Act, for a lot owner of a detached dwelling, you cannot prohibit them incorporating water-wise landscaping. We can still require landscaping design requirements generally, that they do a site plan review process. We can require that plants be maintained in a healthy condition. So it's not install some water-wise plants and then let them die and turn to weeds. We can still have some control over that. We can include even a list of approved mulches and plant types. So we could say, for example, no artificial turf or no bark. If we live, I know some HOAs deal with a lot of wind and the bark just becomes a mess on the sidewalks and everything. We could have a bark size limitation or gravel or, rock, things like that. So we still have some areas where we can have some say in the water-wise landscape design. Okay. Here's an additional adjustment to the water-wise landscaping. Previously, we could not require people to install or keep in place lawn or turf in any area with a width of less than 8 feet. So this would be like a side yard most typically, or a park strip in front of your house. This is the new one. We cannot require an owner to have more than 50% vegetative coverage that is not water-wise. So what we're mainly talking about there is lawn or turf. So if an owner wants to do max 50% turf on their yard, they're allowed to do that, okay? So we could require 50%. We could not require 60%. We could not require 70% coverage. We can go lower if we want, but we cannot require more than 50% lawn or turf coverage. And perhaps some other plant material. I don't know what that would be. I don't think we see a lot of HOAs that say like clovers that require a lot of water or something like that. But hypothetically, there are other things we could not require if it was intense, like moss or something, because that would require a lot of water to keep moss up. So that's not a loophole for green yards. Yes, sir?
So is there anything that requires the HOA to extract lawn? They have to get rid of it.
Okay, great question. To restate it, is there anything that mandates that an HOA extract lawn? And I assume you're talking about areas that the HOA controls. There's nothing about that. So for all common areas or areas that the HOA manages, they are not required to scale back on their lawn and turf. It's totally at their discretion and option if they want to do that. Okay, any other questions? Yes, sir.
Has there been any conversation about getting the cities that have to have their rebates being applied to HOA?
So there has been a lot of discussion about that. The question is rebates and things for people that are flipping it. Is there discussion about mandating it, I guess, statewide is your question?
Well, no, because a lot of the cities that have rebates, they don't let that apply to HOAs.
Yeah.
Because it's not considered a seat residence or whatever.
Sure. There's been no draft legislation to make that mandatory from a state level to extend that, but we are seeing more and more cities, including in southern Utah, expand that option for HOAs. And we're hearing stories from HOAs that are successfully obtaining some of these benefits, these subsidies, to go to drought tolerant or water-wise landscaping. I have not seen anything at the state level though to make it mandatory. If it's
I
something you
comment
think
on
we should push, go ahead.
Well, finish this.
No, if it's something you think we should push, bring it to the LAC though. We can certainly press that.
Yeah, on that, I mean, are you talking like the flip the strip rebate and things like that, right?
Yeah, we obviously have conversations from the landscape perspective with a lot of homeowners, with a lot of managers,
Right.
and we talk about rebates that the state or the city are giving to the city, or to people who flip the strip, but they're not giving it to the HOAs. So I feel like that is something that I would definitely have the line to push to try and get cities to extend that rebate to HOAs.
And some of it could be education. I mean, you know, we're lucky. We've got Jordan Valley Water Conservancy District just a few blocks away right here, right? And they're the ones pushing a lot of this. I mean, a lot of the cities flip the strip program. They're saying do it. It's really just Jordan Valley's rebate program that they're allowing them to market under their city name. And so I don't know any, and some cities may have their own rebate on top of that, but I think most of them are just following Jordan Valley Water. And you could go there. I know at least developers and new builds, Jordan Valley Water, they're pushing out. I mean, they came, I was in a presentation where they were talking about, we're trying to get HOAs to be more water wise, and with developers, they have programs that they can do to you know, give them some rebates. And I think there are some with Jordan Valley, they may have some for HOAs, so we can check on that. I mean, I'm going to be reaching out to that group to talk about some of this. So I think there may be some, so it may just be more of an education component of, it's already available, we just need to get it out there, maybe educate some of the city officials that it can still apply to HOAs. Or if not, don't go through the city, go right to Jordan Valley if they're within this Water Conservancy District.
Awesome. Okay. I wanted to do kind of, okay, there is a definition of water-wise landscaping. I will submit my opinion, it's not that helpful. The main takeaway though is water-wise landscaping is something that requires minimal irrigation or no overhead spray irrigation. So if it requires overhead spray or just as much irrigation as lawn or turf, it's not going to be considered water-wise. But it's still kind of a tricky definition to apply, I think. Okay, I did want to give just kind of a quick summary because this is ever evolving. We had some stuff from last year and this year. They're mandatory, okay, so you have to adopt it. You must support water efficient landscaping. You cannot require lawn on more than 50% of a lot. You cannot require lawn in small areas, side yards, park strips, etc. And you cannot require watering during drought conditions, okay? So if someone wants to stop doing that during drought conditions, we cannot enforce our rules with respect to watering. Okay? All right.
Thank you, Taylor.
Tyler,
Yes.
can you define what overhead irrigation means?
Oh, I don't know that I can. Mr. Bailey, you want to hit that one? I think it's just like pop-up sprinklers. Just any sprinkler irrigation system that's spraying water. That's what I understand it to mean. But what do you have in mind, Todd? What's this?
Is that what we require that they have their irrigation?
Yeah. So I think the contrast they're trying to draw is like drip irrigation at the base of plants versus plants that will require spraying water on them.
I think Todd's concern, and obviously I'm not an attorney, but the way that's written, you can't have turf without pop-ups.
Well, okay, so you can require that on up to 50% of the lawn, okay? So it's not that you can't require overhead spray anywhere, but a homeowner is entitled to, at a minimum, 50% of their lawn being covered with plants that do not require that. Do you see what I'm saying? So if you require lawn up to 50%, you can require irrigation on that lawn section too. Does that answer your question? Okay.
I think, sorry Tyler, I think
Yeah.
my confusion, if you go back on the definition, it says water-wise is considered no overhead spray.
Right, so a homeowner's only entitled to do water-wise, to override the HOA on 50% of their lawn, okay? So if you say, well, we're not gonna approve this, we instead want these plant densities and these plant types, and they say, well, I can't keep these type of plants alive with overhead spray, then that has to be off the water-wise approved list for the HOA. Does that make sense? So if we have things on our list of water-wise approved plants that require overhead spray, that's not okay.
So that definition of no overhead spray does not apply to the 50% turf.
Exactly. It doesn't apply to the 50% turf section. It only applies to the 50% water-wise section, or whatever portion the HOA comes up with.
And I think this highlights something, like with the political signs that we were talking about, came in last year, we knew it wasn't perfect, I mean, they pushed it through. Water-wise, you know, these things, they're gonna just keep coming, right? And so I think an important thing, you know, Jeremy, you and some others that really have this experience in landscaping, you know, if you're looking at some of those definitions, that you're like, you know, those legislators and you guys that are attorneys, that's not practical, that makes no sense, right? So come to us, and then during our LAC meetings and stuff, we can work on some language, go to our representative or senator and say, we need to tweak this to help us better understand what this is and further address the issue, you know, be proactive. So I think that'd be great as you're going out and, you know, and even as you're seeing this and you see some of those issues, bring it to us, and not just on water-wise, other issues, so as LAC we can deal with it, right? And this one on the fees deals with that. Sorry, I know there's questions. Back there, and then Julie.
I can see a lot of push on what qualifies as a water-wise plan. That might need to be refined in your rules and regulations just to make sure it's very clear what actually qualifies. Because I could argue anything. I've learned from Tyler and Quinn and Michael. So that might just need to be really, really clear in those regulations.
Okay. And for the recording, to reiterate what Barry was saying is he has learned a lot from Tyler and I. Oh, he said something else too. I can't help. He was talking about, you know, trying to define what is a water-wise plant and landscaping, and trying to really define that in your rules. You know, that would help. And Julie, you had a question.
Yeah, I was just thinking from a practical perspective, like, you know, associations need to adopt these rules. Like, it could be very simple as just one sentence saying, you know, you're allowed to have water-wise and you don't have to water your lawn in a drought. Or it can be very robust, you know, if you want to have all these details about what it is. But I think, you know, it's important that it doesn't need to be a huge project to comply with the statute.
Right. So again, for the recording, Julie was saying that your rules to satisfy the statutory requirement can be pretty simple. It can be one or two sentences, just saying that water-wise landscaping is allowed, and then you can go in and you know, going along with both of those. Again, I think that's where we can look at the resources at our local water conservancy districts, because they're gonna have a list of here's some plants that are allowed, right? I think of the back to the Flip the Strip program. If you're gonna qualify for that, you don't just get to put in, you know, cement. That doesn't qualify. They talk about it's got to be some water-wise landscaping and elements, and so they'll identify those. So I think as we go and look at those resources, it could be a good guide for us as we draft those rules for our communities. Okay, this one, additional fee for rentals, right? It's happened for several years. We had a bill that was pushed through, I can't remember how many years ago. It was backed by the Apartment Association that really pushed, you cannot treat rentals in your communities differently than anybody else, right? Even though we know there's usually some other issues and administrative things and more complaints that come from rental properties. Not always. There can be some good renters, but it you know, statistically, you probably get more complaints from them, right? But we could not charge an additional fee. We can now. As this goes into effect, you can charge up to $200 annually per rental unit, you know, in the community, with the conditions that your community has to allow at least 35% of the properties to be rentals. Okay, so if you have a restriction that's only 25, you cannot charge the fee. If you allow at least 35, you can do this, and then you have to be able to actually account It's the actual costs that the association is incurring for administrative costs related to that rental property. And so, you know, how are you going to prove those actual costs? The easiest way is, you know, managers, in your contract, it's just saying there are more administrative issues to deal with rental properties, and so we're charging X amount for everyone per year in the community, right? And we're assessing that through up to $200. And so you can go and do that. I was talking to somebody the other day about a self-managed property. They're like, well, can we just charge the $200? It's like, well, you don't have a third-party manager that's charging that. So you have to be able to have some documentation that you can better itemize and identify those charges to be able to do that. So I think it gets a little bit harder for the self-managed communities, but you can look at that and be able to qualify, and maybe they're paying somebody just to track those or something. Question?
I've had a couple of communities that requested like a rental audit to kind of try and determine what their actual percentages based on the info we can get our hands on. And, you know, that's a non-contracted billing, so is that justified?
Yep, absolutely. Yeah, that would qualify. So the question was, I've had some communities ask for an audit to go through the properties and see how many of them are rentals, and you know, would that count towards these actual costs? It would. I know before this program started, I was talking to Barry a little bit. Earlier this week, I was off at a conference for something else. Flew in last night to be back for this. And as I was at the conference, there was one of the vendors who was demonstrating some software more for governments to track short-term rentals, and so that they could just put in, here's the geographical area, and this software would search every short-term rental site and be able to identify how many were within their city, county, whatever. And I went up and asked him, how applicable would that be for an HOA? And he says, oh, we do it for some HOAs in California, and they're a lot bigger out there. But the price was, he charged $35 per property that they identified in your community per year. And so we didn't go into too much detail about everything they offer, but I've got to think as that technology expands, that there's going to be more competitors, and in the coming years, you're going to have options, and it'll be pretty cost efficient to maybe track it that way. That's the short-term rentals, and so there would still be some work trying to identify the long-term rentals, but I think there'll be some help coming in the not too distant future for that. Okay, fractional ownership. So I've got this one, and then Tyler's got one more, and because I know we're short on time, or over, I guess. Was it 10 or 10:30? Stacy, what time did this go to? All day. We're here all day. Okay. So fractional ownership. So this one is not one that the LAC really tracked, and you'll see why. But since the legislative session ended, I know my office has received calls from 4 or 5 communities. It's really big up at Park City. I'm sure you guys have received some too. They're in a panic of we can't regulate this fractional ownership. I mean, they're just going to allow all this. It's basically turning it into a timeshare. Park City, St. George, the resort communities, right? And because that's what this bill, SB 271, it restricts any legislative body of a city, a township, a county, of passing an ordinance that restricts and prohibits people from having co-owned homes or fractional ownership, right? Not like, 2 people, but we're going to split this up for 52 different owners, and you each have 1 week a year, right? Which, by another name could be a timeshare, right? But they don't allow that anymore. It does not apply to community associations. So you can still restrict those type of activities in your governing documents. How we would address that is a different story, but this statute does not apply directly to you, but it has been causing some panic in some of those resort communities.
Awesome. Okay, last topic to bring us home. So in 2014 or 2015, I don't recall, there was this new process put in place for non-condo HOAs for the adoption of rules. You're probably familiar with it, and we'll talk about it briefly. But condos don't have to comply. Non-condos had to give some advance notice, have an open meeting, notify everyone after those rules are adopted in order for that clarification, revision, or adoption to be valid. Well, we did two things with this statute. Number one, we defined what a rule is, okay? And it's pretty intuitive, but the important part is down here at the bottom. A rule does not include the internal business operating procedures of a board. You still may say, what does that mean? But there are certain kind of policies for a board to operate that we didn't want to have to go through this 15-day notice process, okay? So we have a definition that you can check out, and that this is the process I'm talking about. In order to have a valid rule adoption in a non-condo HOA, in the yellow square, 15 days advance notice to all the owners that you're considering the rule change, adoption, revision, clarification, etc. If green represents the official rule change, within 15 days, you have to notify all the owners of what you changed. Okay. In my experience, most HOAs were really botching this. They weren't effectively giving notice. And every once in a while, we would have a savvy owner come in and say, hey, you can't find me. You don't have your records showing you went through this little process. And then once they point that out, maybe they tell their neighbors, and maybe we have 5, 6, 7 years of enforcement that we have to unwind, or maybe we're refunding fines or something like that because we never properly adopted it. The new statute says that if you're going to challenge this rule adoption process, you have 18 months to do it. So there's essentially an 18-month statute of limitations on challenging this process. And the whole idea there is if we've been through a full season and a half of implementation and enforcement of it, and no one's challenged it, okay, that's water under the bridge moving forward. We're good to go. Any questions about that?
Retroactivity.
Retroactivity? So what's your
Well,
opinion
is
on
it,
that?
so is the 18 months only applying to rules that are passed, you know, after this goes into effect?
Prospectively.
Or what if they adopted a rule 3 years ago? Can somebody challenge it now, or is the 18 months already gone?
The intent certainly was to have this apply to even things that happened 5, 6 years ago. I'm not aware of any language in the statute that would limit it to prospective application, but it won't surprise me if someone tries to argue that in our industry. We'll see. But I think the intent is to have it to apply to even things that happened in the past. Julie?
So it's not a challenge to the rule itself, it's just
Exactly.
how the rule is adopted.
That's a very important clarification. The rule itself can still be challenged as being unreasonable or inconsistent with your CC&Rs or incompatible with the Act. This is only a statute of limitations on this process for rule adoption.
Does that include if they update the fine schedule?
Good question. So if we go back to what the definition of a rule is, a policy, guideline, restriction, procedure, or regulation that is not set forth in one of these. So I would say yes, that would qualify as a rule under that definition that we have. So part of this definition is just helping us answer that question. What is a rule that's subject to this section, and what is a rule that's not?
And, can I jump in?
Absolutely.
And that's important. That, I mean, I like the definition here because we've probably all gone through that mental exercise, right? Of like, we need to adopt this rule, but if we don't call it a rule, we call it a policy or a resolution, we don't have to give 15 days notice, right? I mean, come on, you've all been in those meetings where they're talking about that, and that's where it's like, just because you change the name, if the substance of it is a rule, comply with it, right? So I think by adding all of those in, it will try to eliminate some of those mental exercises that people go through to try to justify or get around it. So.
Okay, awesome. I think that's it. Thank you to everyone for attending and our sponsors and for your participation. And go team win. Yeah. Thank you.